Hi, this is Stephen Demopoulos. I'm an estate planning and probate lawyer in Los Angeles. Today, I'll be talking about the drawbacks of using beneficiary designations in estate planning. If you have any questions about what I talk about today or otherwise, you want to set up a call with me, you can go to estate-meeting.com. That's estate-meeting.com. So beneficiary designations, what are they? Essentially, you can designate to whom you want certain assets to pass when you die. You can do this with bank accounts, with brokerage accounts. You can also do it with real estate. The way you do it with real estate is you execute a transfer on death deed. The deed states the intended beneficiaries, and when you die, the property transfers to those beneficiaries. If you have a will or a trust in place, and beneficiary designations, usually for the assets that have the designations, the assets will pass according to the designations and not the will or the trust. If you don't have beneficiary designations and you do not have a trust, what happens to your assets when you die is that they need to pass through the probate court process in order to get to your heirs. The probate process, especially in California, is really burdensome, it takes a long time, and it's very expensive. So it is good that using beneficiary designations avoids probate, but I'm going to go through a few of the reasons why the designations is a less than ideal way to do your estate planning. Essentially, using a revocable trust is much better. So one of the big drawbacks of beneficiary designations is that what happens to you if you become incapacitated. If you have physical incapacity or mental incapacity and you cannot yourself actually access your financial accounts and deal with your financial affairs, what happens then? There is a form in estate planning called a power of attorney form. And a power of attorney form essentially designates someone who can step into your shoes to handle your financial affairs as if it were you. Theoretically, that is what a power of attorney form does, but in practice, actually, power of attorney forms don't work that well, especially if you're trying to deal with banks, financial institutions. Often, banks will just deny power of attorney forms. If the power of attorney form is over 3 or 4 years old, if there's any kind of issue with the power of attorney form, or even if there's no issue with the power of attorney form, often banks will just deny them. The reason probably has to do something with the banks just don't want money being taken out of their accounts, or whatever the reason is, the financial institutions are just becoming increasingly risk averse. The power of attorney forms just don't work very well. I've been in a position of trying to use them for my clients. I've heard of banks, I've heard of this story over and over again of banks just denying power of attorney forms. So they're not that effective. Much more effective than the power of attorney form is to use a revocable trust, to have your accounts in a revocable trust. And then if you become incapacitated, then the successor trustee just steps in your place. And because the accounts are owned by a revocable trust, there isn't so much that the bank can do to deny the successor trustee having access to the trust. So the next big drawback for beneficiary designations is that it's a very messy and cumbersome way to organize your estate and to organize what happens when you die. If you have multiple accounts, multiple brokerage accounts, if you have a real estate, 3, 4, 5, 10 accounts in real estate, for each of those assets, you have to list who the beneficiary designations are. You have to list the contact information for all the beneficiaries. You have to list what happens if those beneficiaries predecease you. There's all this stuff that is involved, all this information. If one thing is wrong, then that can screw up your entire plan. If you want to make changes down the line, if people move, they have different contact information, you have to change that information for each separate asset. So much more convenient than doing beneficiary designations is, once again, doing a revocable trust. You put all of your assets into the revocable trust, and then you can just, if you want to make changes, if you want to make changes, all you have to do is execute an amendment of the trust, and then that changes everything for all of the assets together. Okay, so the last drawback of beneficiary designations is that there's no one, if you just use beneficiary designations, there's no one who is designated to handle the affairs of your estate. What you're doing in that case is, if you're doing designations on bank accounts or brokerage accounts, you're relying on the financial institutions to actually track down the beneficiaries and execute your estate plan and execute your intentions and wishes. Once again, far more superior, far better, and a far more organized way of dealing with your assets is to just put everything in, to execute a revocable trust, put all of your accounts into the revocable trust. And then you can designate someone who you think is responsible and who you can trust, a trustee, to handle your accounts and to execute your wishes as you would have intended. In that way, that's really the most efficient way of dealing with estate planning. Beneficiary designations are okay if maybe you have a small estate or you want to deal with one asset in some kind of specific way or something. But it can get very messy if that is your sole way that you're organizing your entire estate plan. So if you have any questions about what I talked about today, if you want to set up a call with me, you can go to estate-meeting.com. Thanks for listening.